Institutional asset managers handling distressed real estate face a strict operational challenge. Every day a non-performing loan remains on the books, it drains capital. To maintain liquidity, financial institutions must find a way to process thousands of these distressed assets simultaneously, every single day. But standard civil litigation moves slowly, and that inertia inherently favors the defaulting party. Routine delays like stall tactics, third-party standing challenges, and missing chain of title documentation create procedural friction that bleeds capital over time. To overcome this friction, lenders utilize specific, aggressive state acceleration mechanisms to force a resolution. Local judicial authorities, like chief administrative judges, issue standing orders that dictate and enforce exactly how quickly these specific mechanisms move through the docket. But this state-level speed is actively countered by federal regulatory frameworks, which seek to slow the disposition process down to protect consumers. The intersection of these two opposing forces, state judicial acceleration and federal regulatory friction, dictates the exact timing and success rate of recovering an asset. Survival in default servicing requires weaponizing state procedural laws to systematically bypass standard litigation inertia. In Florida, the primary legal engine designed to expedite foreclosures is State Statute 702.10. The statute allows a lien holder to file for an order to show cause. This mechanism bypasses standard hearing queues, allowing a judge to immediately review the file in chambers. This timeline maps the statutory milestones once that order is requested. Day 0 is the filing of the initial complaint. The statute imposes a strict initial wait time. The court cannot hold a hearing sooner than 20 days after the defendant is served. There is a secondary chronological constraint. The hearing cannot occur sooner than 45 days after the initial complaint is filed. Once that time elapses, the procedure inverts. The burden of proof completely shifts off the lender and onto the defendant. To stop the foreclosure, the defendant must proactively file verified, sworn defenses that raise a genuine issue of material fact. If the defendant fails to meet this verified evidentiary standard, or if they simply fail to appear, they automatically waive their right to a hearing. This waiver allows the lender to move immediately toward a final judgment of foreclosure. This breakdown illustrates the financial anatomy of that final judgment, awarding principal, accumulated interest, and attorney fees. To control legal costs, 702.10 implements a statutory cap. Without a hearing, requested attorney fees cannot exceed 3% of the principal amount owed. For non-owner-occupied properties, the statute includes an asset preservation provision. The court can force the mortgagor to either make payments during the pendency of the case or vacate the premises entirely. By utilizing 702.10, lenders transform a drawn-out war of attrition into a strictly timed sprint, where the defendant must proactively prove why they should not lose immediately. Even on this expedited track, lenders face a vulnerability that can derail the entire process: missing physical documentation. Mortgages are routinely sold and transferred between institutions. During these transfers, physical promissory notes are frequently lost, or they fail to receive the necessary legal endorsements. A recent case litigated by the law firm Kelly Cronenberg serves as an ultimate stress test for how the system handles missing documents. The lender sought an $832,000 judgment against a third-party purchaser who had acquired the property through an HOA foreclosure. An HOA, or homeowners association, is a community organization that enforces neighborhood rules and can levy liens against a property. The defense attacked the servicer's legal standing to foreclose, arguing that the copy of the note attached to the complaint was missing a required endorsement. This graph maps the chain of custody, from the originating lender to a first transferee and finally the plaintiff. The missing endorsement represents a clear break in this evidentiary chain. To cross this gap, litigators invoked Florida Statute 673.3091. This statute allows a plaintiff to prove a continuous chain of ownership by submitting targeted, comprehensive affidavits detailing exactly who owned the note when it went missing. These affidavits legally reestablish both the specific terms of the lost instrument and the legal right to enforce it in court. The judge ruled in favor of the servicer, determining that the defense's speculation could not defeat the substantial, competent evidence of ownership provided by the affidavits. A broken evidentiary chain is not a fatal flaw. By deploying targeted statutory cures, litigators can systematically reconstruct the legal right to enforce a debt. Executing state-level procedural acceleration secures the judgment, but that is only half the battle for an asset manager. Following a successful foreclosure sale, lenders face severe back-end constraints that limit their financial recovery. In 2013, then-Governor Rick Scott codified a major back-end limitation. Scott signed the Florida Fair Foreclosure Act into law. The act drastically reduced the statutory limitations for pursuing a deficiency judgment, the personal money judgment for the remaining unpaid debt, from 5 years down to exactly 1 year post-sale. This diagram illustrates the competing forces acting on the life cycle of a distressed asset. On one side, state statutes aggressively compress the timeline. On the other side, federal deceleration mandates expand the timeline and actively block state-level actions. The Department of Housing and Urban Development, or HUD, routinely acts as a systemic deceleration mechanism through directives like Mortgagee Letter 2025-12. HUD is the federal executive department responsible for national housing policy and programs. This specific letter restricts borrowers to utilizing only one permanent loss mitigation option every 24 months. These new permanent loss mitigation constraints go into effect on October 1, 2025. Beyond scheduled regulations, there is an unpredictable timeline disruptor that supersedes all state and federal standard operating procedures, natural disaster moratoriums. When catastrophic weather events destroy physical properties, federal overrides immediately freeze the legal machinery. Following recent storms, HUD Secretary Scott Turner invoked this exact federal authority. Turner mandated a 90-day extension on foreclosure moratoriums for all single-family mortgages insured by the FHA in areas impacted by Hurricanes Helene and Milton. The FHA, or Federal Housing Administration, is a government agency that provides mortgage insurance to protect lenders against defaults. This mandate locked all foreclosure actions in those regions until July 10, 2025. Profitable default servicing ultimately requires flawlessly executing aggressive state-level legal sprints while constantly recalculating to survive immovable federal administrative roadblocks.